and I will let you go ahead.
Great. Thanks, Ginny, and thanks so much for inviting me today. It's really exciting to be back with this chapter and to see some familiar faces. Um, Great. So let me go ahead and share my screen. Okay. Can everyone see?
Yep.
Okay. How do I minimize the? Yeah, here we go. Okay, great. Today I want to talk pretty quickly about the topic of state responsibility for climate change. And so what I mean by that is this question of what are the obligations that states owe to each other and to the international community in the context of climate change? And can we use international litigation as a tool when those obligations are not being complied with? And because this is a really big topic, I want to focus down on the specific example of Brazil and climate change harms arising from a deforestation of the Amazon rainforest. So when I gave this talk with Nadine and the Asian Pacific Action Team, I was able to get to 2 out of 3 things. And so I think I'll aim for that again today. And those would be first to kind of go through the legal steps, the legal arguments that would be needed in order to successfully bring an international contentious litigation, that is country versus country, against Brazil in the case of the Amazon. What would be needed to successfully invoke the 2001 UN articles on state responsibility for internationally wrongful acts. And then kind of backing up in the second part to look more broadly at, well, why hasn't such a case already been brought? Why does this case not exist? Or for that matter, any other case targeting a country's actions on climate change? Why don't we have this? What are the limitations and barriers to this approach? And then finally, hopefully spilling into the Q&A, I will kind of back up and look at the role of law and litigation and where it can help and where progress is actually being made already. So of course, the Amazon needs no introduction, but I will give it a very brief introduction. So the Amazon rainforest is the world's largest carbon sink. It holds 10% of the global carbon sequestration capacity, as well as a quarter of all species on the planet. However, since the 1960s, for decades now, harms have been arising from agricultural expansion, from road construction, generally economic development, commercial logging. And these harms have accelerated, particularly under the agenda, the anti-conservation policies of the current president of Brazil, Jair Bolsonaro. And this has led to increasing international concern and of course the question of, what can be done? Can the international community step in here? And so that brings me to the document itself, the 2001 UN articles on the responsibility of states for internationally wrongful acts, which sounds like a big mouthful, but basically it exists to provide a formal process for state A who feels wronged or harmed by the actions of state B to call on state B to stop or to cease, to not repeat what they're doing, and then to provide some kind of reparation or compensation. And so a big topic recently has been, the idea of compensation for climate change damages. And so this set of articles kind of opens the door to explore what that might look like in the case of Brazil, maybe. So how do we successfully invoke these articles? And so making a gross oversimplification here, there's basically 4 things. And that would be that state A needs to show that state B has actually violated some kind of treaty obligation or has violated a customary principle, like some kind of principle of general international law. Then that harm arising from this violation is actually attributable to the state, that there's a causality between this violation and this climate change harm. Third, that the state that's committed the harm does not have any kind of valid excuse, a justification, a circumstance precluding its wrongfulness. And fourth, there's a question of who is actually allowed to bring this case against Brazil, who is eligible to be compensated, and to whom does Brazil owe these obligations. And I'll get into all four of these now. But just quickly, I want to say that I'm going to on the first point, focus on a violation of customary international law rather than treaty obligations. Treaty obligations in the context of climate change, we have the Paris Agreement. And the Paris Agreement does not have any explicit dispute settlement provisions. It has a very intentionally designed compliance system, and I will touch on that later in a few minutes. So there are many general principles of international environmental law, and what I present today is just one potential option for a litigation. But among these principles is prevention. And this is the idea that states have the responsibility to ensure that activities within their jurisdiction do not cause damage to the environment of other states or of areas beyond the limits of their national jurisdiction. And of course, that's a very broad idea. And this has been fleshed out through decades of cases. And so I will simplify into a short checklist of what we need to show that this principle of prevention has actually been breached in the case of Brazil. And so there are 4 points here. And the first is the harm actually happening? Is deforestation in Amazon actually happening? And the answer, of course, is yes. This would be relatively easy to show with satellite imagery, the well-documented effects of deforestation, and the increasing pressures from road construction, from large mining projects, etc. So this point is quite clear that this is not hypothetical, this is really happening. Secondly, is this harm significant? And significant is a subjective term. It's not legally defined, but we can turn to the science here to help us understand that, well, yes, as the world's largest carbon source, carbon sink, the Amazon, deforestation of the Amazon, it poses particular challenges, pushing us towards climatic tipping points. This is accelerating us on the path towards dangerous warming, and that is significant. And we don't just have to take the science word for it. We can take the word of other cases. For instance, the Supreme Court in Colombia, where the Amazon extends into some other countries in the region. The Supreme Court of Colombia has said that these harms represent an irreversible and existential threat. And so if that's not significant, then I don't know what is. Third, we would need to show that the harm is actually transboundary. And as people interested in climate change, we know that this is a global problem. We know that greenhouse gases mix uniformly in the atmosphere. We know that where emissions are coming from, affects all countries, particularly through the mechanism of sea level rise, through rising temperatures, et cetera, et cetera. So we would have to rely on the climate science to demonstrate that deforestation in the Amazon is not just a local problem. Finally, most interestingly, we would have to show that Brazil has not taken due diligence to prevent this harm. And by due diligence, we mean that a country, just because a harm happens on the country's watch, does not mean that country automatically we can trigger state responsibility. If, for instance, they had in place very robust policies designed to prevent deforestation and biodiversity loss, and if they had taken a good faith, I'm sorry, is there, hello?
Go ahead, I think that was an accidental.
Oh, okay. Right, so if there was a good faith effort on the part of Brazil to implement anti-deforestation policies and still some harm happened, then we could argue that yes, they took due diligence and they can't really be held responsible. But in this case, that's not really what's going on. We see that Brazil has frozen the federal budget, including for the Ministry of Environment, which is in charge of implementing conservation programs and working with indigenous communities in the Amazon for the next 20 years. And so that's really crippled the effort to prevent these harms. And there's been really a dismal record of enforcement of the environmental policies that are in place. And so there's certainly reason to believe that due diligence has not been taken in this case. And there are scientific articles and a consensus opinion that is what's going on. So second, let me turn to whether or not we can show that harms from Brazil are actually attributable to the state. And ways to show that are twofold. First, are agents of deforestation under Brazil's direct control? And in fact, we see that yes, they are. For instance, this is a mining operation by Vale, which is a company that's the world's largest extractor of iron ore in the Amazon. And so this kind of operation, which is conducted by a state-sponsored, a state-owned enterprise, gives a kind of the Brazil's stamp of approval to the consequences of these actions. And then secondly, has the state taken steps to mitigate harm by private actors? And we see that, that's basically no, and particularly with the president encouraging informal development and agricultural expansion, there has been relatively little effort to stop those actions. Thirdly, under the articles on state responsibility, there are a set number of arguments that Brazil may put forward to demonstrate that, well, they actually needed to take the actions that they did. It was okay, and they shouldn't be held responsible. And those are that they could have done what they did in self-defense, but this is irrelevant because there's no war in Brazil at the moment. They could have done what they did because of force majeure or some kind of emergency situation, an act of God that required them to deforest. Again, not really relevant here. They could have done what they did because the international community consented to the harm from deforestation. It was actually, agreed to, and certainly that's not the case. But more interestingly, they could argue that they did what they did because of economic necessity or because there was going to be a famine or some kind of circumstance where the only possible way they could have avoided this terrible situation is by deforestation. However, even in this case, we see that international courts are very skeptical of the idea of economic necessity. And Brazil is actually among the most food secure developing countries with a malnutrition rate of just 2.5% in 2019. And so really there was no kind of circumstance like this that could justify 50 plus years of deforestation. Finally, there's this question of who can bring the case, who is getting compensated, to whom are these obligations owed. And under the articles, if that obligation is owed to the international community as a whole, then any state can bring the case. But we hadn't actually seen that happen until this particular year, until 2020, when the Gambia brought a case before the International Court of Justice holding Myanmar to account over alleged genocide against the Rohingya Muslim minority in Myanmar. And what is fascinating in this case, why it is relevant for climate change, is that Gambia has nothing to do with the Rohingya. The Gambia is an African nation. However, under the Genocide Convention, they argued that Myanmar owed the obligation not to commit genocide to the international community as a whole. And therefore, the Gambia was able to bring this case, was able to say that they have essentially standing and bring Myanmar before the International Court of Justice. And so we see that, for instance, small island developing nations that are under threat from sea level rise might say, well, the obligation not to cause these harms from Brazil is owed to the international community as a whole. And so we, even though we're halfway across the world, are still affected and should be compensated here, and the case should move forward. Okay, so let me put away all of that kind of legal side of this presentation. And basically the point of all of that was just to say that, the elements needed to bring an international climate litigation against Brazil are very likely there, but this case doesn't exist. So why not? Let's look at a couple of very important reasons. The first is that jurisdiction in the international community is it's a very difficult issue to navigate. And what we mean by this is that because Brazil is a sovereign nation, because any country is sovereign, you cannot just subject them to a decision of an international court unless they consent to the jurisdiction of that court. And under the Paris Agreement, there is no explicit provision saying that all disputes are going to be settled before such and such court. In fact, it's highly unlikely that Brazil would consent to the jurisdiction of, for instance, the International Court of Justice, the Permanent Court of Arbitration, or any other court. And we see that this has happened in the past, where in the landmark decision of the South China Sea arbitration in 2016, Philippines brought a case against China for illegal taking of endangered species and territorial claims in the South China Sea. And the PCA, the Permanent Court of Arbitration, ruled that yes, in fact, China had breached the prevention principle, the same principle that we're talking about here, and needs to, stop its actions in the South China Sea. However, China completely rejected the jurisdiction of that court and of course the resulting ruling, and continues to this day to act in total contravention of that decision. And so you might ask, well, what was the point of the decision in the first place if the jurisdiction cannot work out? The second reason why such a case might not exist is that we're operating under the Paris Agreement framework here, which is a facilitative process by design. And the Paris Agreement, under the Compliance Committee, the idea is to help countries meet their nationally determined contributions to reduce emissions and collectively limit warming to less than 1.5 degrees Celsius. And to do that, we really need to work together. We need to, have developed countries providing climate finance, capacity building, technical assistance, technology transfer to developing countries, working collectively under this very facilitative process to meet this goal. And a contentious case, country versus country, is certainly going to undermine that collective spirit. This picture comes from the COP, the Conference of the Parties, I believe COP23, when the Fijian presidency introduced what's known as the Talanoa Dialogue, where countries essentially sit together and share stories about what is working, what isn't working, where do we want to go, how are we going to get there. And so it's really introduced this collaborative spirit. And in order for that to be fostered in the future, we can't really afford to bring a contentious case blaming countries or trying to punish countries for not meeting their obligations. Thirdly, I would mention this, what if we go through all of this trouble to bring this case against Brazil, and then we win, and then, we, for instance, as the United States, are allowed to claim some kind of compensation from Brazil. Certainly, that would not work because under the Paris Agreement, we are a developed country, they are a developing country, and it runs counter to the spirit of global climate action to have this kind of reverse power dynamics at play, and so winning this case would still entail helping Brazil, to develop alternative conservation practices and try to improve conditions in the Amazon, which could be done without kind of holding their feet to the fire per se. And then the doomsday scenario, of course, is what if the international community loses? We bring this case, all the way to, for instance, the International Court of Justice, and they say, well, actually, Brazil doesn't really owe the international community anything to, stop climate change damages that are happening. This could really set back global efforts on mitigation, on adaptation for a long time. And we see that this has happened in the past as well. After the Cold War, when countries thought that the use of nuclear weapons would, by definition, violate the prevention principle. And so they brought a case before the International Court of Justice, and the ICJ basically said, well, actually, nuclear weapons might still be able to be used in self-defense or in other circumstances, and that set back global nuclear deproliferation efforts for about 20 years. And in the case of climate change, we certainly do not have 20 years to recover from a decision that goes the wrong way. Right, and so if we're not going to bring an international contentious case against Brazil right away or ever, there are a number of things that we could do instead. One is an advisory opinion, where an international tribunal simply interprets the law without a particular context, which could, symbolically advise parties on what to do and push them in the right direction without blaming anyone per se. There are a number of domestic litigation cases as well, where NGOs, where civil society are holding governments as well as individual emitters, carbon majors, big companies accountable for climate change damages, which have seen progress. And I think there are also, of course, economic and political levers where we can put pressure on decision makers to take climate change into account without bringing a formal litigation. There's much more to say about this, but I think I'm going to stop there and open up for Q&A if there are any questions. And hopefully I can touch on some of the progress that I see being made in terms of climate law in the Q&A. And so a quick thank you to the team at Cambridge who helped to kind of inform this presentation. And with that, I really will stop. So thank you so much.
Great. Wow, Tim, thank you so much. That was really fascinating and so clearly explained. I really like the way you made all those points. So let's